early days of January 2024, a seal was broken that the world had been waiting for with bated breath. This was not a physical barrier, but a judicial one. Within the sterile, mahogany-lined walls of the U.S. District Court for the Southern District of New York, Judge Loretta Preska issued an order that would send shockwaves through the corridors of power. Thousands of pages, previously shrouded in secrecy, began to flood the public domain. These were the Epstein files, a massive cache of court documents, depositions, and internal communications that threatened to pull back the curtain on one of the most prolific and high-profile sex trafficking operations in modern history. The names contained within spanned the spectrum of global influence, from royalty and heads of state to titanous figures in business and academia. Or this release was not a sudden accident of transparency, but the culmination of a decade-long legal struggle aimed at bringing accountability to a network that many believed was untouchable for far too long. The genesis of this revelation dates back to 2015, long before the general public understood the full scale of the tragedy. It began with a civil defamation lawsuit filed by Virginia Giuffre against Ghislaine Maxwell. Giuffre, who has emerged as a tireless advocate for survivors, alleged that Maxwell had facilitated her abuse at the hands of Jeffrey Epstein and his associates. While that specific lawsuit was settled in 2017, the vast majority of the evidence gathered during the proceedings remained sealed. For years, these documents sat in digital and physical vaults, protected by protective orders and legal maneuvers. And the legal battle to unseal them was spearheaded not just by Giuffre herself, but by investigative journalists and media outlets who argued that public interest outweighed the privacy concerns of those named. This wasn't just about sensationalism. It was about understanding how such systemic exploitation could occur under the noses of authorities, revealing a dark infrastructure that relied as much on prestige as it did on coercion and predatory behavior. To understand the weight of these files, one must revisit the dark history of the man at the center of the storm. Jeffrey Epstein's criminal timeline is a story of repeated failures of justice. In 2008, he secured a controversial non-prosecution agreement in Florida that allowed him to serve a remarkably light sentence for soliciting a minor. It took another 11 years for the federal government to move against him again, resulting in his 2019 arrest in New York on sex trafficking charges. His subsequent death in custody left a void where a trial should have been, leaving many questions unanswered and many victims without their day in court. However, the pursuit of justice did not die with him. Ghislaine Maxwell, his longtime companion and primary facilitator, was arrested and convicted in 2021 for her role in recruiting and grooming young women. Now serving a 20-year sentence, Maxwell has become the face of the operation's mechanics. Yet the unsealed files suggest that she and Epstein did not act alone. As the documents began to drop in tranches, a media frenzy gripped the digital landscape. Social media platforms were ablaze with rumors, often centering on the concept of a singular client list. In reality, these documents are far more complex. They consist of flight manifests, hotel records, and detailed transcripts of depositions, where witnesses like Johanna Joberg and victims describe the inner workings of Epstein's residences. While many names are now public, Judge Preska maintained certain redactions to protect the privacy of Jane Doe's, victims whose identities remain sensitive. The scope of information is staggering, offering a granular look at the logistical management of a global enterprise. Before we continue into the specific names and accusations, subscribe to the channel and tell us in the comments where you are watching from. And the narrative of power and historical silence is only beginning to unfold as these documents provide a clear map of the world Epstein built and the individuals who frequented his most private estates across the globe. The unsealed documents acted as a spotlight, illuminating the names of some of the most influential people in the world. The release provided a map of social power that stretched from political leaders to Hollywood icons. Among the thousands of pages, the names of former President Bill Clinton, former President Donald Trump, and Prince Andrew appeared repeatedly, often in contexts that demanded further scrutiny and public explanation. In Clinton's case, the documents included depositions from Virginia Giuffre, stating she saw the former president on Epstein's private island. And though Clinton's representatives have consistently denied he ever visited the location, Donald Trump was mentioned in the context of social visits and flight records, though no specific accusations of illegal activity were leveled against him in these particular filings. Alan Dershowitz also featured prominently due to his long-standing association with Epstein and the specific accusations made by Giuffre, which he has vehemently denied for years. It is critical to distinguish between mere association and criminal accusation, a nuance that was often lost in the media firestorm. This was a network built on silence and leverage. The appearance of a name in these court records does not automatically imply a crime was committed. Many names belong to people who were simply part of Epstein's vast social circle. Lawyers, journalists, academics, business leaders, and acquaintances who may have attended a dinner party or traveled on his plane without participating in the trafficking ring. However, for others, the context was far more damaging, appearing in the sworn testimonies of victims who described a culture of facilitated abuse. Virginia Giuffre's testimony provided the primary backbone of the legal pursuit. Her depositions painted a harrowing picture of life within Epstein's orbit, spanning his opulent Manhattan mansion, his Palm Beach estate, and the secluded shores of Little St. James in the U.S. Virgin Islands. She detailed how she was transported between these locations, treated essentially as property to be shared among Epstein's elite friends. Similarly, Johanna Sjoberg's account added a layer of specificity. Sjoberg described a 2001 incident at Epstein's New York residence involving Prince Andrew. She alleged that the royal had touched her inappropriately while they were sitting on a couch with a puppet, a claim that the Duke of York has denied. These accounts were sworn testimonies that finally allowed the public to see the specific high-stakes allegations that had been whispered about for decades. The files also shed light on the cold, calculated mechanics of the entire operation. Recruitment was often disguised as an opportunity for massages, a euphemism that masked a much darker purpose. Young women, many of them in vulnerable financial situations, were lured into the circle with the promise of easy money for providing what they were told would be simple therapeutic services. Once inside, they were groomed and pressured into more explicit acts. This was an international network, with travel logs revealing frequent trips to Paris, London, and the Caribbean. The operation was governed by strict house rules that prioritized secrecy. Employees, from housekeepers to pilots, were instructed on how to handle visitors and ensure that The movements of certain guests remained confidential. It was a logistical masterpiece designed to maintain a facade of high society elegance while masking the predatory reality occurring behind closed doors. Following the release, the fallout was immediate, and new representatives for the high-profile figures named issued swift rebuttals. Legal teams for those mentioned emphasized that their clients had no knowledge of Epstein's crimes, often dismissing the mentions as hearsay. Ghislaine Maxwell's own defense team had fought the release until the very end, arguing that the unsealing would cause irreparable damage to reputations and unfairly prejudice the public. Conversely, lawyers for the survivors, including those representing Jeffrey and Sjoberg, celebrated the release as a long overdue victory for judicial transparency. They argued that the public deserved to know the names of those who enabled or ignored the abuse, insisting that the truth was the only way to provide genuine validation for the victims who'd been silenced for over a decade. The release of these documents did not just satisfy a global curiosity, it shattered the long-standing illusion of the global elite's immunity. For decades, the wealth and influence of those within Jeffrey Epstein's sphere acted as a suit of armor in protecting them from the usual consequences of legal and social scrutiny. When Judge Loretta Preska ordered the unsealing, that armor did more than crack. It disintegrated under the weight of public observation. The resulting outcry was not merely a reaction to the illicit acts described, but a visceral rejection of the perceived two-tier justice system, where the powerful operate by a different set of rules. This shift in public perception has been permanent, replacing a culture of hushed whispers with a loud, international demand for total institutional accountability. Political and social consequences followed closely behind. Mentions of high-profile political figures were immediately weaponized across various factions, turning court filings into potent ammunition during sensitive election cycles. However, the most significant institutional impact was felt in the boardrooms of global finance and the halls of prestigious academia. Banks like J.P. Morgan Chase and Deutsche Bank faced grueling legal battles and public relations disasters for providing the financial infrastructure that allowed Epstein's operation to remain liquid and mobile. The eventual settlements paid by these institutions served as a grim acknowledgement of their role in sustaining a predator's lifestyle long after his initial 2008 conviction in Florida. Similarly, universities and charities were forced to confront the ethics of accepting donations from a man whose criminal history was a matter of public record, leading to a massive reevaluation of philanthropic vetting processes worldwide. For the survivors, the unsealing of these files represented more than just a legal development. It was a profound victory of narrative. For years, women like Virginia Giuffre and Johanna Sjoberg had their stories dismissed as fabrications or opportunism. The release of these sworn depositions and corroborating logs acted as a formal validation of their lived experiences. The symbolic importance of having these facts entered into the public record cannot be overstated. It was a form of justice that surpassed the limitations of criminal sentencing, ensuring that the truth of their trauma was no longer a secret kept behind the heavy doors of a New York courtroom. This provided closure. For those who were once powerless, the unsealing represents a permanent record that cannot be erased by money or influence. Also, the future of the investigation now rests on the potential for new charges. While the central figure is deceased and Ghislaine Maxwell is serving her 20-year sentence, the files contain a treasure trove of leads that could trigger fresh criminal or civil inquiries into surviving associates. Legal teams and independent investigators are currently cross-referencing the newly released names with existing evidence to identify any patterns of complicity or perjury. Furthermore, the Epstein case has fundamentally altered the legislative landscape. The Adult Survivors Act in New York stands as a direct testament to the influence of this case, providing a vital legal avenue for victims to seek redress long after statutes of limitations have expired. This law has already allowed many individuals to come forward who would have otherwise been silenced by the passage of time. Despite the massive amount of information, the fight for transparency is not entirely over. A small number of redactions remain as the court continues to balance the public's right to know with legitimate privacy concerns of victims who have not yet stepped forward. These remaining hidden details ensure that the Epstein story will stay in the legal spotlight for the foreseeable future. The legacy of these files is one of hard-won transparency. They have served to debunk many of the wilder conspiracy theories that clouded the case, replacing speculation with a sobering, documented reality of how power was wielded and abused. The saga reminds us that the pursuit of justice against the global elite is a slow, yet arduous process. But the unsealing of these documents proves that no secret is forever, and no individual, regardless of their wealth or status, is truly untouchable in the eyes of the law. It serves as a stark reminder that the shadows of power can eventually be pierced by the light of public scrutiny and judicial courage. The ongoing struggle for truth remains a fundamental pillar of a functioning democracy.